बोर्ड ऑफ एडवांस स्टडी से उसे एकेडमिक काउंसिलर आगे
Hello, everyone. The live has begun. Director, sir, please, we can start.
Hello.
Sir, we can start now.
Thank you. Good morning, distinguished participants. I am Akmal Azad, Director, Bangladesh International Arbitration Center, BIAC. BIAC is the country's first and only licensed alternative dispute resolution institution, which since its inception in April 2011 has been handling ADR cases chiefly under its own rules of arbitration and mediation, and has started to resolve loan dispute cases through mediation. Bangladesh has a total of over 37 million case backlogs in all types of courts across the country. On 18 December 2019, President Abdul urged all concerned to take steps to use ADR. Mentioning that it is very difficult to carry out judicial work, the President said, "You will have to take steps for using alternative dispute resolution to reduce the growing backlog of cases." With the serious backlog of pending cases in courts, BIAC is trying to integrate ADR mechanism with the court proceedings with a view to quick dispensation of justice and thereby increasing the country's position in the Doing Business Global Index so as to invite more foreign direct investment and help overall economic growth of the country. Amidst uncertainty of a global economic recovery, the government has set a target of 8.2% gross domestic product growth for the current fiscal year 2020-21. With a view to achieving this target, we must ensure enforcing commercial contracts and help ease doing business in the country, which can be done through institutional ADR mechanism, for which BIAC has been trying to raise a human resource base through training of stakeholders at home and abroad and exchanging views with them through discussions, seminars, webinars, workshops, consultations, and so on. BIAC is a member of the International Council for Commercial Arbitration, ICCA, and also recognized nationally and internationally. We have signed 42 MOUs and cooperation agreements with international ADR institutions, including the Permanent Court of Arbitration, PCA, The Hague, the Netherlands, local banks, corporate bodies, law chambers, universities, and NGOs. We have reacted to the current global crisis of COVID-19 pandemic and the future new norms for the handling of dispute resolution. Under the program of holding a series of webinars during this COVID-19 crisis, we are now set to start the 4th webinar on ad hoc versus institutional alternative dispute resolution, which is aimed to discuss on the advantages and disadvantages of ad hoc and institutional ADR. Through this webinar, we'd like to draw recommendations from experts as to how different types of ADR mechanism at this difficult time can help resolve commercial disputes in the most pragmatic, expeditious, and cost-effective manner. We have with us here a distinguished panel of expert speakers who will address issues and impacts of ad hoc and institutional ADR with special emphasis on arbitration and mediation. By sharing experiences from business leaders, experts from the legal fraternity, bankers, academicians, and ADR specialists, this webinar will offer help and guidance to the stakeholders facing the challenges of resolving business dispute issues during the current catastrophe of COVID-19, which has created an unprecedented challenge in our economic life. I will request Barrister Saqeb Mahbub, Advocate, Supreme Court of Bangladesh, to moderate the webinar. He is an advocate of the Supreme Court of Bangladesh and partner of Mahbub and Company. A corporate and commercial lawyer, Barrister Mahbub advises and represents clients on corporate, employment, contract, investment, mergers, and acquisitions matters. He started his career at Hawk and Company, where he was a part of litigation and arbitration team. During his time there, he advised a major US bank on financial laws in Bangladesh. my privilege now to hand over to Barrister Mahbub to conduct the session. Barrister Saqeb Mahbub.
Thank you, Akmal Bhai, for the kind introduction. It is a great honor to be moderating this webinar with such an exciting panel here with us today. I would like to thank all of them for being with us, and also the audience for joining us this morning early on in the week. Hope you all had a good long weekend. So I will not take too much time because I am also really excited to hear from the speakers. So, but just a little bit about the topic. Why is this topic important? Just like everything in our personal, social, and professional lives, COVID-19 has had an impact, and dispute resolution and commercial dispute resolution in particular is no exception from that. So starting from there, I would say that one trend that is now common across all sectors is the need for efficiency. So this, and while a lawyer may be practicing it, it is the client who pays for dispute resolution, and every business now is looking for efficiency in every way possible. So it is only natural that a client would be looking for efficiency in how it resolves its business disputes as well. So we have long ago figured out that the traditional court-based litigation is not the most efficient way of resolving disputes. So the much celebrated way was arbitration, and arbitration was great. It took less time than the court-based litigation. It was flexible, it was confidential. Parties could choose their own arbitrators, and so party autonomy was there. But the reality is that ADR has not taken off as well as we would have liked it to, particularly in Bangladesh. And when we ask what the barriers are, we hear things like it is too costly, or it still takes a long time to resolve. It is not quick. So when we are facing these problems, a solution that may come to mind, and that is the perhaps the discussion that is required from this webinar, is whether these problems can be solved by institutional ADR, and that is what we will discuss, hopefully. So first and foremost, I would like to invite Mr. Osama Taseer, who does not need much of an introduction, but for the benefit of the audience, Mr. Taseer is a leader in the business community. He is the immediate past president of the Dhaka Chamber of Commerce and Industry. His sector is the RMG industry, and he's also a former director of the BGMEA. Mr. Taseer, it's a great pleasure to have you with us today.
Thank you. Thank you. Thank you for the introduction.
So, it would be great to hear your thoughts. You are free to speak as you like on the topic, but if I may ask, how the business community looks generally at commercial dispute resolution, and what are the expectations, and how much of it is fulfilled in the current way of current state of how things are, and also just a little, if you could add on in your capacity as an RNG exporter and part of that community, which was hugely affected recently by disputes with international buyers, whether you see, or whether in your community you have talked about or thought about arbitration or institutional arbitration as a way of resolving these disputes. Over to you, Mr. Taseer.
Thank you very much. A very good morning to everybody in Bangladesh and overseas, especially in India. I was a bit stuck up on the way in. I'm sorry for joining in late. To start off with, arbitration is a form of alternative dispute resolution, which allows disagreements between two parties to be resolved outside the traditional court of law, as you already mentioned. An institutional arbitration versus an ad hoc one is a bit of catchy, how we can address it. An institutional arbitration is one which is a specialized institution intervenes and takes on the role of administrating the arbitration process. Am I audible?
Yes, you're audible.
Each institution has its own set of rules which provide a framework for arbitration and its own form of administration to assist the whole process. I gather there are around 1,200 institutions worldwide which are offer arbitration services. I may be wrong, maybe it's increasing even though. If we try to compare what are the advantages or disadvantages, it can be many, but in a limited time I have, is that for an institutional arbitration, the availability of pre-established rules and procedures is a big advantage. Administrative assistance is there, a list of qualified arbitrators, assistance in encouraging reluctant parties to proceed with the arbitration itself, an established format, and with a proven track record. Institutional arbitration saves parties and their lawyers the effort of determining the arbitration procedures. An institution's panel of arbitrators will usually be made up of experts from different sectors of the world and include many different vocations. To counterbalance sometimes the risk of awarding, some institutional rules provide for scrutiny of the draft award itself before the final award is issued. So these are some of the specific advantage of an institutional arbitration. As you said, if we compare the disadvantages, it is the cost, administrative fees for the services and use of the facilities. If there is any internal bureaucracy in the institution itself. And sometimes because of institutional arbitration, the parties may be required to respond within a time frame which is beyond their capacity sometimes because they are not used to these sort of things. As you said, it's still not, arbitration is still not very common as we would have wanted it to be. Now, if we go to the ad hoc arbitration, the parties therefore have to determine all aspects of the arbitration themselves. Number of arbitrators, appointing them, etc., etc. Procedure for conducting the arbitration. Often, we have seen that appointing a qualified arbitrator can lead to the parties agreeing to designate an institution provider as the appointing authority. So there is a overlapping here. What are the advantages? Properly structured ad hoc arbitration should be more cost-effective, apparently, if it goes smoothly. A primary advantage of the ad hoc process is its flexibility because two parties can decide how they want to do it. If the parties agree that their arbitration should be conducted under certain arbitration rules, this will result in reduced deliberation and legal fees at times. The United Nations Commission of International Trade Law arbitration rules revised in 2010 is among one of the suitable rules for such ad hoc arbitrations. One of the reasons the ad hoc arbitration may be less expensive is due to pay fees for the arbitrators. The arbitrators' fees will be negotiated directly and the parties and the arbitrators allowing them the option to negotiate. So that is one advantage. What could be the disadvantage of an ad hoc arbitration? A distinct disadvantage of the ad hoc process is that its effectiveness is dependent on how willing both the parties are to agree on the arbitration procedures at a time when there may be already a dispute between the two parties. Often the parties may misunderstand each other because they come from different backgrounds, jurisdictions, etc. The arbitrators are the judges in the case and no party would wish to upset the judge, particularly before the proceedings have been commenced. Parties wishing to include an ad hoc arbitration clause in the underlying contract between them have the option of negotiating a complete set of rules which meet their needs. However, their approach can require considerable time. So if we just try to conclude, I don't know how much time I have, around 7 to 8 minutes, is that although ad hoc arbitration requires cooperation between the parties, understand arbitration procedures, arbitration itself is conducted by experienced arbitrators, but still in today's modern and commercially complex world, it is really only suitable for smaller claims involving less affluent parties in domestic and regional arbitration, where they can understand each other very well. In the context of international commercial disputes, institutional arbitration may be more suitable. Despite being more expensive, time-consuming, and perhaps rigid, the institutional process provides established and up-to-date arbitration rules, support, supervision, and monitoring of arbitration, review of the awards, and strengthens the award's credibility. The particular circumstances of the parties and the nature of the dispute will ultimately determine whether institutional or ad hoc arbitration should be more suitable for a certain case. So, what you had asked me in the beginning is that regarding the RNG industry and what really happened as we sit in a, let's say, I don't know if it's a proper world, a pandemic world, and try to look back. Yes, definitely a lot of contracts fell apart. And I think you must have your personal experience also, people running to you to get some advice on how to do it. And actually, a lot of things were not covered. And I'm sure that as an industry, we must look into this option, because otherwise we are going to face similar problems in the future. And we still cannot really fathom what are the real-time losses we had to incur, because there was no such provision in our contracts. They're very simple. There's only one way out. There was no way to get both the parties to adhere to certain norms and ethics. So I will stop at this moment. I'm around 7.5 minutes. So let's see, and we'll take it up when it comes. Thank you very much.
Thank you, Mr. Taseer. I think COVID has been quite a wake-up call for everyone, and I'm thank BIAC for this timely webinar, and a couple of previous webinars which also has delved into this issue as well. So as you said, ad hoc in theory can be cheap and quick, but obviously it presupposes that that the parties are cooperating with each other throughout the process. But when they are in a dispute situation, it may not be the case. So yeah, I think that's a very, very important point. Next, I would like to invite Barrister Imtiaz Farooq. Imtiaz Bhai is an advocate of the Supreme Court of Bangladesh, and he is a leader of the legal community. He is currently the Assistant Secretary of the Supreme Court Bar Association. Imtiaz Bhai is an Oxford alumnus and a very busy practitioner. He regularly takes part in arbitrations, both as an arbitrator and as an advocate. Imtiaz Bhai, welcome to our webinar. Are you there? Can you hear me?
Yes, I can hear you. Can you hear me?
Great. Yes, I can. Imtiaz Bhai, it would be great to hear your thoughts from your experience as an arbitration practitioner. And I guess what I want to know from you is how you see the choice between ad hoc and institutional arbitration playing out, particularly in this COVID and the post-COVID reality that we are in. Yeah, the floor is yours.
Thank you, Saqeb. I think a key aspect that we who advocate for arbitration, sometimes we forget that arbitration is still an adversarial system where two parties are against each other. And more often than not, one party may have a real perverse incentive to delay the proceedings. So if we see this in the context of COVID-19 and the effects surrounding it, we need to really assess the suitability of institutional rules to deal with such an issue. Before that, let me share a very quick story with you. Like last week, I was in an arbitration, and it was an ad hoc arbitration, and the arbitrators were doing a virtual hearing. So the question one of the parties raised was that, okay, fine, we are doing a virtual hearing, but what about the order service? The order was served by an email, and we don't accept that, and it should have been served in person. So as you see that in a COVID scenario, where people are trying to move towards further efficiency and where in-person hearing scope is limited, we are trying to achieve something, there can be still these kinds of issues. So what I was very keen to see that how institutional versus ad hoc would deal with such an issue. Now, the supposed best thing about institutional arbitration is that the rules are preset. We know it from day one. What are the rules, right? So now when COVID has happened, we had no knowledge that this is going to happen. So what happens to the arbitration which were ongoing, and then suddenly this COVID scenario has come in? So if we look at, say, for example, BIAC rules, and you would see BIAC rules, for example, notice can be served by email, which is very good, and that can be like very we can use it virtually. Now, if you look at further procedural rules in BIAC, you will see that there is a pre-conference which is allowed to happen over teleconference. But about other hearings, BIAC rule does not say anything. In the pre-conference, the arbitrators can decide on any effective measures that they would want to take, but the similar power is not given to them in between. So if a hearing has started, if we are, say, 2, 3, 4 hearings down the line, then there is no provision in the BIAC rules which allows the arbitrators to reset the rules, because that was supposed to have been finished in in the preliminary conference, Rule 13(1)(c). So, whilst going forward, BIAC may change its rules and bring in virtual hearing procedure, what happens to the arbitrations which are in between? And it's not only about BIAC, it's SIAC, and every other institution is facing this challenge. In April, there was a joint declaration by all the big boys, and they, what they said was that this is an extraordinary scenario, so they urged everyone to take constructive method for efficient completion of hearing. Now, what the message is that there is no mandatory obligation on parties to change what they have agreed. So if the rule does not allow web-based hearings, you can't change in between. And also, the call was that let's be pragmatic and do what is good for efficient hearing. But as I was saying, that there may be a party who doesn't want to do that, who wants to delay the process. So in an institutional arbitration, in a COVID-19 scenario, for arbitrations which are ongoing, there are only 2 ways to do it. Either arbitrators can try to impose a decision. But if you impose a decision, as I was saying, that because the rules are supposed to be preset, you can't impose a decision. And if you impose a decision, then that can be challenged for breach of procedural, agreement. Like, for example, under our Arbitration Act 43, 1A5, if the arbitral procedure was not in accordance with what the parties had agreed, the arbitral award can be challenged. So really arbitrators have no power to impose sort of web hearing in an institutional scenario. Alternatively, can they agree? But if they agree, then the institutional arbitration becomes sort of ad hoc. So what we are seeing is that institutions are now having to adopt ad hoc rules to deal with this. So I personally think that at least in Bangladeshi context, our ad hoc arbitration under Arbitration Act 2001 is more suited for this kind of scenario. Because if you see section 23(1), it says that any method, arbitrators are supposed to conduct hearing in any method which is fair and impartial. And section 25 also sort of similar ethos. So therefore, even in between a hearing, say even at the examination stage, now COVID-19, like in the arbitration that I was in, the arbitrators were said, okay, I'm going to give a ruling that you have to accept e-service. And they had the power to do so under the ad hoc rules, because the ad hoc rule is backed by the act, and they can change the rules ad hoc. So it's an interesting scenario that in a COVID-19 scenario, I think more flexibility is perhaps what we need. Now, for example, BIAC, I was thinking like BIAC Council has a power under their Rule 31 to interpret their rules. Now, should BIAC maybe look at Rule 31 and see that whether they can extend the power of the preliminary proceedings to all of the proceedings, all these. So I think institutions now are having to learn it the tough way, like all of us. So they should adapt going forward. They should change their rules. They should think about cybersecurity, effectiveness, and equal participation. But for ongoing arbitrations, I think there is a serious concern that all parties must be on board. And it has to be a carrot and stick process. Like, arbitrators have to really say that if you don't agree, then I'm going to be very upset, and nobody wants to upset the arbitrator. So I think it has to be a carrot and stick to sort of reach that. I think that were my initial comments. Thank you.
Thank you, Imtiaz bhai. I think one of the great advantages of institutional arbitration is, of course, the predictability of the rules. So you don't have to go in and have to decide on rules. It's already decided. You know what it is. But I guess COVID-19 threw us a ball that we could not catch. No one did, right? No one knew it was going to happen. But of course, going forward, virtual hearings are a must. I think every institution is now kind of adapting to that. Obviously, even without COVID, in international commercial arbitrations where a witness is abroad or something like that, it's massively helpful to in those situations as well. So I would like to move on now to our next speaker. I'd like to invite Professor Jamila Chowdhury. Professor Chowdhury is a professor of law at the University of Dhaka. She holds a PhD in dispute resolution from the School of Law, University of Sydney, Australia. She's a celebrated academician in the dispute resolution sphere. Professor Chowdhury, it's a pleasure to have you with us. Can you hear me properly?
I'm hearing, yeah.
Okay. We can hear you as well, and the volume, if you could keep the mic close to you throughout, that would be great. Yes. Hello.
Are you hearing me now?
I can hear you. Yes, I can hear you. Yes.
Thank you.
Okay. So, Professor Chowdhury, it has been one of the biggest selling points of arbitration and ADR against traditional litigation as a whole. Has been the confidential nature, the aspect of party autonomy, that parties can choose their own arbitrators, they can choose their time and date and their own language. Do you think that institutional arbitration kind of defeats that point by putting parties from one institution, which is the court, to another institution, for example, the ADR? Or do you think it's a necessary evil? But the floor is yours. You can also respond to the previous speakers as well.
Yeah, dear panelist, moderator, colleagues, practitioners, and other attendees in this event, a good very morning at all. So for idea, I recall 31st August is the anniversary day of BIAC. Last year, I attended the 8th anniversary of the BIAC at Shunaga Hotel. It was a massive program, in fact. But this year, perhaps due to the COVID-19, not perhaps, certainly, it's a virtual program we are celebrating. Nonetheless, I appreciate BIAC for organizing such a virtual program titled Institutional ADR and Ad hoc ADR. I completely agree with my earlier panelists, what they have stated. But my particular focus is, particularly, I very much agree on Imtiaz Bhai. I'm saying him as Bhai because he is one of my colleagues' spouse. So it's better for me to say him Imtiaz Bhai. So I completely agree with him, Imtiaz Bhai, as well as earlier panelists, regarding the institutional arbitration and ad hoc arbitration. Institutional arbitration is almost a win-loss approach. That means an adversarial approach, very akin to trial. It takes time, more time, though it's specific. If I just compare with ad hoc arbitration, obviously it has some advantages over ad hoc, or vice versa. To some extent, ad hoc has some advantages too. But my particular focus is, from the very inception of this seminar, I'm finding that the title is Institutional ADR versus Ad hoc ADR. But nobody, still I didn't find anybody has, perhaps it's me, who would be the first one who will speak on institutional mediation versus institutional arbitration. Since it is ADR, everybody is focusing on the very often used jargon, institutional arbitration versus ad hoc arbitration. As I am an academician, and I am ultimately teaching ADR in the LLM level at Dhaka University and as well as some private universities. So I find that while the term ADR has been used, at the time we should not confine ourselves with only within the term arbitration, institutional or ad hoc arbitration. Rather, it should be extended, especially during this COVID crisis, it should be extended to institutional mediation as well as ad hoc mediation. So this is one point which I find that is absent in our discussion, that should, and in my thought, that should be added here. And regarding institutional arbitration versus ad hoc arbitration, since there is a versus, we are making a comparison. I think this kind of comparison, to some extent, it's my view, to some extent is not appropriate, because depending on the context, sometimes ad hoc arbitration may be perfect, sometimes it's institutional. But so far I understand most of the panelists as well as the experts will argue for institutional arbitration rather than ad hoc arbitration, or institutional mediation rather than ad hoc mediation, or institutional conciliation or ad hoc conciliation. So ultimately, what I would like to fix up, since there is a time limit of 5 minutes, initially I would like to proceed throughout the PowerPoint. Later I thought that perhaps it will be time consuming and it will be lapsed with another panelist, so it's better for me not to say or not to touch. If I just see about BIAC, SIAC, HIAC, DIAC, CITAC, whatever regional institutional arbitration in regional level or in the international level, ICC, PCA, Permanent Arbitration Court, there are some advantages, I agree. It's preset, arbitrators, parties can, huge autonomy, they can choose their arbitrators. It can be sole or 3 or any odd number. However, for me, still now, it is adversarial, it is time consuming, to some extent, it is structured, obviously, but differing from other panelists, in this COVID crisis, in fact, my second argument is that I am supporting, in terms of advantages, the ad hoc arbitration or ad hoc mediation or ad hoc conciliation or whatever. So ad hoc is sometimes, we undermine to some extent that there are some disadvantages of ad hoc since it is not structured. But the if we just consider about the context of COVID, my first argument, I'm just summing up my argument. The first one is that ADR should not be confined only within the arbitration, rather it should be extended to some other forms, primary at least. There are hybrid also. So hybrid could be also the ad hoc form or institutional form. Made up could be an institutional, made up institutional or ad hoc. The second point is that ad hoc arbitration generally, other than COVID crisis, in a general time period, if I just consider, obviously, at the time, institutional arbitration like BIAC, Saqeb, whatever I mentioned, regional or international arbitration centers, is doing really good. But in COVID crisis or post-COVID crisis, it's my, again and again, I'm saying it's my opinion that perhaps ad hoc arbitration would go better. Thank you so much.
Thank you, Professor Chowdhury. I think it's great to have your view on this issue. Definitely, ad hoc arbitration or other form of ADR does provide that flexibility, which is much needed in a surprise situation like COVID. Um, uh, Moving on to the next speaker, I'm glad to have him here. He is Mr. MD Abdul Wadud. Mr. Wadud is a Deputy Managing Director of Citibank and is the head of the Commercial Trade and SMEM business segment. He also looks after the Supply Chain Finance, Legal and Special Management Division of the bank. And he represents Citibank in the board of IDLC Finance as well. Mr. Wadud, it is a pleasure to have you with us.
Thank you, Mr. Saqeb. I hope
Thank you for joining us.
Clear?
Yes, the sound is clear. First of all, please, of course, feel free to respond to what the other speakers have said on the topic. Additionally, since you are representing the banking sector in this panel, I would like to get your thoughts on the scope and possibilities of using both ad hoc and institutional ADR in the recovery of non-performing loans, which are obviously a great problem in our economy right now.
Mr. Saqeb, you have just made my life easy because I'm not a lawyer, and in fact, my deep into very minimal knowledge of ADR started through BIAC when while we were negotiating with them, or they came to us for incorporating the clauses related to ADRs into our various agreements, in addition to recovery activities. So I will start with non-COVID situation. I mean, before COVID situation, you know, we try to solve our cases in going to the court year after year. It is continuing, and the time is elapsing. So at that time, this institutional ADR approaches came from BIAC, and also it is continuing since long, but somehow it is not coming into picture. Now, if we consider COVID situation, you see, for a reasonable time, the court was not operating. So what happened? What was the situation of urgent cases and other things? So definitely the alternative to going to the court again comes into picture more effectively. Either it is in the determinative form or elective form. I'd like to say various modalities of ADR while we are practicing recoveries comes like conciliation, mediation, settlement conference, arbitration, maybe appellate ADR, or even a village court, or maybe a traditional salish, which are practiced in Bangladesh. So if we come into discussion about institutional ADR, let me try to identify that let me talk about what is helping us. For example, say BIAC is an institution for an ADR. They have some preset rules and procedures, which is makes us starting something in a timely manner. Also, we can get the administrative assistance. Definitely, there are qualified arbitrators or mediators choose from their right panel. makes the ADR or makes the decision effective. And also, most importantly, we see in a ADR that sometimes the parties are very reluctant. They don't understand how to start, when to start, or sometimes they don't like to start. They do not understand the benefits not going to the court, or don't rely upon not going to the court. So institutional arbitration actually helps in encouraging the reluctant parties here. And sometimes the established format, which have a proven record, also helps to proceed with institutional arbitration. Definitely, it has some limitation like cost. My previous speakers said cost or sometimes bureaucracy, and also sometimes it comes into picture some unrealistic time frame. So as Imtiaz Farooq bhai said, that in such cases actually ad hoc arbitration comes into picture, and which is much more helpful. Actually, most important benefit of ad hoc arbitration is, or ad hoc mediation, is that it is flexible. Parties can begin proceedings as they will not have to engage in negotiating specific rules. So they can be, it can be more cost effective. Also, sometimes there are some very small claims wherein going to an institution actually doesn't make sense. So in that cases also the ad hoc arbitration or even the mediation can work properly. So is ad hoc less expensive than institutional? Sometimes it may not be. For example, an ad hoc ADR may not prove to be less expensive than initial process. Firstly, the parties are required to make arrangements to conduct the arbitration mediation, but they may lack the necessary knowledge and expertise. So ad hoc arbitrations are generally conducted by people who may not be lawyers. However, this may result in misinformed decisions, especially in international commercial arbitrations. Secondly, wherein there is a lack of cooperation between the parties, or delays on the part of the tribunal conducting an arbitration or writing the word, a party may need to seek to the court intervention again, which means we are again back to the pavilion. Thirdly, in complex cases, ad hoc tribunal may seek to appoint secretary to deal with the considerable administrative work involved. So that administrative cost may also increase the parties' burden. So to me, it should be a combination depending on the nature of the case involved, the suit amount and others. However, as you said, in terms of recovery, I will relate it to recovery, especially, banks proceed with Orthorin Adalat Ain 2003, especially. It speaks about mediation after initiation of Orthorin suite in the sections 22, 23, 24, 38, 44A, and 45 of that act, where even if the contesting parties agrees to go for the mediation, they have the liberty of walking out of it at their will. Therefore, this post-litigation mediation or arbitration, whatever it comes into picture, is found less effective and used as a time-killing tool by the contesting parties. At pre-litigation stage, since the parties have not yet taken an adversarial position, mediation is far more likely to be effective, resulting in a lot more out-of-court settlements. So what I try to mean is that when you start a court process and then in between this ADR comes, so that should not be the way. The ADR should be something, it should be something binding, which is before going to the court, you have to come into this. The situation should be something like this. In terms of, say, execution of arbitral award, we all know that arbitral award is binding and has got enforceability of a court decree. It is also executable outside the courts through New York Convention. We all know that. So when a defaulter flees, the jurisdiction awarding paying up arbitration award can be enforced against him, and his properties can be attached to it through the local court's order upon bank's claimants and application and submission award. So I would like to request for building up a situation wherein before going to the court, something comes into picture that whether mediation or arbitration, it has to cross before we go to the court. And also, you know, I would say a very important weakness in case of a mediation or arbitration, that you can leave it at any point of time. But say in a court, you cannot leave it by solving it, either losing it or either winning it. So in a arbitration, if we can incorporate some process like this, that you have to come to a decision, even if you go to the next level of court, that I disagree to certain of these things which have certain courses. So therein, it may be handled. It may add some values over it. So our SMD and collection teams generally negotiate with the defaulter borrowers and sometimes interact with a third party while coming into discussion. For example, sometimes it is a village leader or somebody else. It is a form of basically mediation. So by the way of this practicing, we are actually slowly coming into this. So let me talk about Citibank's stance on ADR. Citibank has already signed an MU with BIAC and been incorporating mediation and arbitration clauses in our commercial contracts for quite a while now. And by introducing this, we have created some scope for discussion. And especially this COVID-19 situation wherein people going out is getting difficult, this ADR is much more effective, especially I would say the ad hoc arbitration or mediation, whatever comes, it should be much more lucrative in such a situation. So all the best wishes to BIAC for their success, for their coming success. I heard about a success on 18th March 2020. They settled their commercial dispute through a fast-track arbitration process probably for the first time under its rules. The dispute between a Bangladeshi and a Japanese company arose often eradicating backlog. It's surely a new beginning towards fast dispute resolutions and many more to follow this role for surely. Thank you.
Thank you, Wadud bhai. Thank you for your thoughts. I think you make a very important point regarding this post-litigation mediation that is provided for in the Orthoni Adalat Ain. And it really the parties are already in a dispute situation. They're already in an adversarial situation, and it's really not a great time to be doing mediation at that time. So pre-litigation mediation if possible, but obviously we would need a legislative change to make that happen, and hopefully that will soon come. Next on my list is Barrister Suhan Khan. Suhan is an advocate of the Supreme Court of Bangladesh. He specializes in admiralty and commercial litigation, mergers and acquisitions, corporate transactions, arbitration, foreign investment facilitation. He's the managing partner at Accord Chambers, a full-service law firm in Bangladesh. Suhan, can you hear me properly?
Yes, I can hear you, Saqeb.
Great. Okay, so Suhan, please, of course, feel free to respond to any of the issues raised by the previous speakers. Additionally, from your experience, what would you think is the biggest advantage of either institutional arbitration over ad hoc or ad hoc over institutional? And in the Bangladeshi context, We know that arbitration is now being known as more expensive, sometimes even slow, because there are multiple levels. Parties are challenging it in courts. Appointment of arbitrator is something that takes a long time when done through courts. So perhaps institutional arbitration can solve that. So yeah, your overall thoughts on the two systems of ADR. Floor is yours.
Thank you very much, Saqeb, for giving me the floor. And I would also like to thank BIAC for organizing such a timely webinar and for having me with the esteemed panelists. Well, what I'd like to say at the very first place is that we would, in order to understand the advantages of institutional arbitration over ad hoc arbitration, or arbitration generally over litigation, we would need to look back and see how the dispute resolution, alternative dispute resolution has evolved globally. You know, at a time when we initially developed a judicial system with formal rules of the judicial system, civil procedures for that, and then the rules for appeal. And then when the litigation process was turning out to be costly, time-consuming, inefficient, that is when the concept of arbitration came in. And the whole concept of ad hoc arbitration was the beginning of arbitration. But over the years, you know, as Imtiaz Bhai already mentioned, even arbitration is adversarial in nature. And therefore, one of the parties who would be concerned about the outcome of the arbitration going against his interests would not essentially readily cooperate with the process. And that is where the old problem of delay and complexity comes in ad hoc arbitration. And that is exactly where the doctrine or the concept of institutionalization of arbitration came in, and the arbitration institutions evolved to be the main forum of dispute resolution. In Bangladesh, we still have the judicial system, but then arbitration clauses became increasingly popular. So if you see 15 or 20 years earlier, the contracts executed at that time, it would only mention that the disputes would be covered by the laws of Bangladesh, and the Bangladesh courts should have the jurisdiction of that. Now we do have arbitration clauses in almost all the construction, commercial contracts, and even most of the contracts we have. But if you look into more developed countries such as Singapore, Hong Kong, or even India, you will see that they have now moved from ad hoc arbitration to institutional arbitration. And you would actually rarely find a cross-border contract that has an arbitration clause that's not institutional arbitration clause. You will always see that they're now going for either ICC or SIAC or Asian International Arbitration Center. So now the global trend is institutional arbitration. And Saqeb, you should also understand the reason for that. You see, one of the so-called advantages of ad hoc arbitration is the flexibility of the parties, as my fellow discussants have mentioned today. But that actually comes at the very expense of the very reason for which arbitration was taken as an alternative of litigation. Because with that flexibility, the failure of one party, or in some cases both the parties, to cooperate on arbitration rules and the appointment procedures can actually result in higher costs, delay, and the need to seek recourse from courts. As you can see in Bangladesh, what you see is one party appoints the arbitrator and the other party fails to appoint the arbitrator, and then you have to go to the district judge's court for appointment of arbitrators. Why is that happening? That is happening because of this apparent flexibility, which is actually acting to the detriment of the very purpose of referring a dispute to arbitration. So this, I believe that the advantage of having a pre-established rules and procedures, such as in Bangladesh, BIAC has its own rules and procedures, and the fact that it has within those rules and procedures specific ways and avenues in which those procedural fallacies can be avoided, like appointment of arbitrators, time frame issues. These actually mean that without institutional arbitration in the future, Bangladesh will not be able to step up to the position of other countries like Singapore or other developed countries who now have stepped up into institutional arbitrations. So I believe that we should take that step. Otherwise, the problems which we are facing will carry on. And another issue which I will share from my own personal experience is that in ad hoc arbitration, the fact that the parties have to discuss about the fees with arbitrators. Saqeb, you and Imtiaz, everybody, you've acted as counsels and arbitrators in various arbitrations. The fact that we counsels, when we advise our client as to who should be appointed as the arbitrator, and then we have to go to the arbitrator to discuss about the very fees of the arbitrators, and that may be very awkward. Because since no parties wishes to upset an arbitrator, and it's also not always about upsetting, it's also feels uncomfortable about that. So in institutional arbitration, we don't have that problem. And also we eradicate the uncertainty of costs that is involved in litigation. And we can only eradicate that uncertainty of cost when we go to the institutional arbitration. Because in institutional arbitration, we can advise our clients as to the probable cost of the whole arbitration process, because BIAC has its own set of fixed rates of the arbitration costs and reference points, and also dependent on the subject matter and the value involved, just like the ICC or CIAC. So when we are advising our clients, it's much useful for us as legal counsels in arbitration if we can actually avail that. And speaking about costs, well, litigation, because of the delay, was expensive at the end of the day. And that's why we still believe, although arbitration can apparently look expensive, but at the end of the day, if you look into the years of paying fees in litigation, arbitration might actually be more effective and cheaper in some context. So in terms of the cost of institutional arbitration, even if it apparently appears to be a little expensive, but I personally would not say that, because I have had some bitter experiences of ad hoc arbitrations going for years. In two of the arbitrations, the arbitration tribunal was formed in 2017. I'm acting as the legal counsels. Even today, we have not really gone anywhere because of this very open and apparent flexibility which our other contesting parties have misused. And the chances of that in dispute resolutions by institutional arbitration is not there. I would like to just cite two very examples from my personal experiences of institutional arbitration. So I was acting as a legal counsel in one of the international arbitrations in GAFTA in London. So my one of my deadline procedural time limit was set on 10th of October. Alhamdulillah, I became a father on 8th of October. So I sought time. And the next thing I heard that my time was allowed because of the special circumstances, but that it would not be allowed in the future. And then, for another reason, separate reason, I had to seek for time on the second occasion being a counsel and was rejected. And I had to actually comply. So this was there. And in another arbitration in Singapore, it was under the ICC arbitration rules. I arrived in Singapore a day earlier than ahead of the arbitration date. And then my other side, which was from Bangladesh, they sought a time petition in that arbitration. Because, we have that tendency from a Bangladesh perspective, unfortunately. And the arbitrator, who was from Allen and Gillette Hill, it was the sole arbitrator, he straight away said, this is out of question. And then we went on to the hearing and I obtained the award actually ex parte. So you see, this is required for effective dispute resolution if you want to make it. And the fact that BIAC is there, I think that it has the full potential to follow the footsteps of SIAC or Asian International Arbitration Center or Hong Kong Arbitration Center. And if rightly used, if incorporated in all the contracts, especially in the public sector is encouraged in all the EPC contracts or in the private-public partnership agreements. If we start to incorporate BIAC rules and BIAC as the institutional arbitration, I think we are going to see a better future. And I think we are going to have a prospective, good way, a better way to resolve dispute. And lastly, I think we should all mention one thing, that is, in many cases, even if the arbitration rules do not mention BIAC rules, you can always opt in if the other party agrees. And that can be also an option if you have not done that already. So I think, institutional arbitration is the future.
Thank you, Suhan. Thank you so much. I think, yeah, in cross-border commercial agreements, I think you would hardly ever see now an ad hoc arbitration clause. So it would definitely be institutional arbitration, whichever country it is. You shared a couple of personal experiences. I think they resonate with my personal experiences as well. One of my first assignments when I became a lawyer for the first time was to do an appointment of arbitrator in court, in the district court of Dhaka. And it took 2.5 years and 16 adjournments by the district court. And then I left the chambers. I didn't know even, I don't know if that appointment actually happened. And, and cost, speaking of cost, sometimes what is happening, it is very unfortunate that in an ad hoc arbitration scenario, we are negotiating a cost for say 10 sittings with the chairman, and it just happens that the matter is adjourned for very unimportant reasons, and it goes over the 10 sittings, and the arbitration is still not resolved. So you have to pay for another 10 sittings or at least 5 sittings. So the cost keeps increasing that way, and obviously there's a culture in our courts of seeking for adjournment. So the practiced norm is that whenever a lawyer says that I have some personal difficulty, the court doesn't ask any further question about what that difficulty is and grants time. And that culture has been taken and imposed in the ad hoc arbitration system as well. So courts are very willing to give adjournments whenever a lawyer is saying that I need some more time to prepare a claim, counterclaim, etc. So that the delays in litigation we have actually now taken to ad hoc arbitration as well. So yeah, I definitely resonates with my practice, and I think also Imtiaz bhai would agree with most of what you said. So moving on to Kritika. Kritika Krishnamurthy is a professional mediator and negotiator trained from the Ministry of Law and Justice, the Government of India. She's joining us from India today. She is the director of Bridge Policy Think Tank India. She is the co-author of a legal best-selling book titled The Art of Negotiation and Mediation, Wishbone, Funnybone, and Backbone. She mostly practices private commercial mediation, but is also empaneled as mediator with the National Company Law Tribunal and the National Company Law Appellate Tribunal in India. Kritika Krishnamurthy, thank you very much for joining us.
Thank you so much for the introduction. And in fact, telepathically, if I may add, so you spoke about something that I wanted to address. I heard all the panelists, and it was a pleasure to hear views of Bangladesh on this very interesting topic on which I have been researching and talking about and helping institutional ADR centers in India. And you used a very important word. And I think after all these discussions on whether procedure is important, whether the legislation is important, I have come to one conclusion in the last, I think, 9 years. And that is that culture is key when it comes to ADR. You see, I'll begin with a very small example. Imagine you're in an international airport. right? And you're in an international airport of a country where the food preferences are very different from what you generally eat. That happens a lot with people like me because I'm a vegetarian, even in a non-vegetarian country. But so you're walking down the stalls and you're looking for something to eat. And suddenly you notice there's McDonald's, there's Nando's, and maybe there's mainland China. What do? You don't even think twice. You'll walk into the McDonald's and order the kind of burger that you generally eat or something like that, right? You're in a shopping mall. You shop at Marks and Spencer's. You shop at Louis Philippe. Why is that so? Now, before I give you the answer to that, I'll tell you what we do with ADR services in India and Bangladesh. First of all, I want to thank Bangladesh. Thank you, thank you, thank you for being honest. You see, in India, if I would have organized such a webinar, people would have spoken high and low about institutional arbitration, extolled on its virtues, and told me that it is the best and that is what we should opt for, and then gone and opted for an ad hoc arbitration. And, I have clients in India who are now saying that we are so fed up with ad hoc arbitration that we would just not want to have arbitration as a dispute resolution clause in our contract. And we would just like to go to court because anyway, we will get an arbitration award. And then if we don't win, we are going to appeal it, right? And so what do we do? And then I tell them that, no, that's not generally necessary. You can go for an institutional setup and they'll provide you professional services. And what will happen at the end of the day is you will be satisfied with the outcome. And when you're satisfied with an outcome, you will think objectively on whether or not you want to appeal it. Now, before we go to that, what do we do with ADR service providers in our countries? So we're all facing the same problem. Users are generally opting for ad hoc ADR services when it comes to local arbitration or local mediation, right? And in India, anyway, most of the local mediation is court annexed, and that by itself becomes institutional. And I am myself a private mediator, but over a passage of time, I have started opting to even do my private mediations through an institutional service provider. And I'll tell you why by the time we reach it. Very interestingly, even our previous speaker told us that, Barrister Suhan Khan, that when we go to other jurisdictions, so in our jurisdiction, we will opt for ad hoc ADR. When we go to other jurisdictions, what do? Do we look for retired judges or someone else who's providing ad hoc ADR services in those jurisdictions? No. So when we go to Singapore, Thailand, Hong Kong, or London, we automatically opt for the best institutional ADR service provider there, right? And you'll be very surprised to know, and there are neuroscientists working in Geneva. Their life aim is to study the human mind in a conflict situation. So we choose McDonald's, we choose Marks and Spencer's, we choose local ad hoc ADR, but institutional, international ADR, all for the same reason. And that same reason is psychological and neuroscientific, and it's called cognitive bias, right? And it's a cultural thing. We have certain biases regarding a system, right? I heard many things that I wish was not how the system was, because when we say ADR, the tenets of ADR is flexibility. We opted for ADR because litigation was too procedural. There are codes of civil procedure that we need to follow in litigation, and in ADR, following those procedures is optional. You can get away with them. You can even have an arbitration agreement that says that in 3 sittings, the award has to be given, right? And you will be bound by that. But, we have biases and we come from a culture. So in South Korea, they've done a study which says that, you see, ADR, it has its roots in jurisdictions like Europe and the USA. You have European cultures which are similar to Asian cultures, by the way. But the point is that South Asians generally are avoidant people. Once we are in a dispute situation with someone, we don't want to face them. We want to just take our dispute, take it somewhere else, subcontract the entire problem and tell them, you please deal with it for me now. I don't want to deal with it. But when you lose, okay, and winning is important. When you lose, you're like, I am not going to go into the merits of whether my loss is objective. I am going to appeal this, and I'm going to appeal it till I don't have any other option left. And sometimes I face this problem, especially with public sector undertakings, and that is, even after appeal and even after, they will not comply. They will refuse to pay whatever damages they're supposed to pay. And why is that so? You see, for example, I'll give you an example. When you're dealing in limited information, you look for efficiencies. You look for thinking that my job needs to get done. So where do I go? And so when someone points you to an international institutional ADR provider, you go there. If I have a client in India who wants to invest in Bangladesh, the first thing I'm going to do, and I'm going to tell them, is that if you have a dispute, look, I'm going to put a BIAC ADR clause in your contract, because BIAC is the best according to me, and you should go there if you have a problem in Bangladesh, right? So has in Bangladesh or in Dhaka, have you ever required a foreigner to come to you and tell you where you get the best kebab or where you get the best fushka? No. But when it comes to ADR services, look, this is what you're looking for. And that is because culturally, we have held too many biases in our mind. ADR per se is a very flexible system. Go to your institutional service provider and tell him that this is what I want when it comes to rules. And they will change it for you because it's private, because it's possible, and because it should be possible. And this is my main argument today. Every single market is generally a consumer-driven market, right? Until the consumers of dispute resolution services don't come forward, put their foot down and say, this is what we are looking for, the market is not going to improve. We can keep crying hoarse about the requirement for having change in law, change in policies, and change in what a service provider provides. But let me tell you a very surprising thing. ADR is so flexible that it's like getting a custom-made suit, right? From a tailor who specializes in that. Go to your service provider, tell them what you want and get it. And in that case, ad hoc is not different from institutional. In fact, an institutional service provider gives you more variety in terms of arbitrators available, in terms of, you can tell them, I want to finish this in this timeline, and they will do it for you. But the problem is that you will go to them, and I want to talk directly, to the business users of this country. And I want to tell you that the story of ad hoc versus institutional ADR, you see, is a management mystery and a business problem, right? All of us know that accreditation of arbitrators, grading of arbitrators, bringing the services of arbitration mediation in your country up to a certain good uniform level is not possible unless there is more institutional ADR as compared to ad hoc ADR, because it's very difficult to enforce policies on qualities and standards in ad hoc situations. Right? In India, we had Justice Sri Krishna committee set up to check how we could adopt more institutional ADR in India, move away from ad hoc, because we have reached a certain level of ADR. And now if we want to cross that barrier, we have to give more importance to institutional ADR, right? So as a user, and COVID has given you that opportunity. By the way, the United Kingdom has issued a notification, a government notification, requesting business users to opt more for negotiation and more for ADR to resolve their disputes to save the economy. Go and check that notification, because we're always so inspired, Commonwealth countries, with what UK does, right? So go back, dear business user, really go and check the cost of your dispute. And now it's showing very glaringly on your balance sheet. It's a very big overhead cost, right? But that's just the cost that's visible to you. You're not looking at the hidden costs. Ask yourself how many hours your manager, the billable hours your manager is spending in court, asking for orders for appointment of arbitrator, impartiality of the arbitrator, or change of arbitrator, or on some rule when you're opting for ad hoc ADR. Ask yourself the hidden cost of finding a new supplier every time you are in a dispute with a supplier and it drags on for years and you stop taking supplies from him, right? Look at the hidden costs that you're incurring, because on the face of it, you feel that ad hoc ADR is better, or that going to court gives you time, just because culturally we are used to avoiding it. We're like, just file a legal notice, file a court case, or file an ad hoc ADR and forget it and move on with business. That's like, piling up stuff in your home because you're afraid of cleaning it. And someday that pile is going to rise and rise and you won't have place to stay. And then what are you going to do? Right? And so it's only when the consumption patterns of business users change that this entire problem is going to change. Start demanding for things and the market will provide it to you, because that is how they will, a service provider can survive in a market. And go to your institutional service provider and be clear on what are the issues you're facing. We already know what issues we're facing, and that's the best issue, that's the best thing. Go to them, tell them this is what you want, and see if they don't deliver. And that is the bias you need to get over. And I think if we have that, India, Bangladesh, we all, as a jurisdiction, have the potential to become the next Singapore or to become the next Thailand. But that will only happen when we start appreciating what we have domestically and not constantly look outside, at the other side where the grass is greener. So that's my take.
Thank you, Kritika. It was great to hear your perspective, and I don't think you speak for India only. I think you really spoke for Bangladesh as well. I think the cost that we associate is with arbitration is not just the money that we're paying upfront, but it is also the time that is spent on finding an arbitrator, the time that is spending on finding a venue to do it, booking a venue, and so much more. So we really need to go back to the drawing board and see how we want to take this flexibility that we really that we are quite obsessed about, and how we deal with that. So I think that was a great session. It was great hearing from the speakers, and so we'd like to go to Q&A, a short Q&A. As moderator, I'll take the liberty to ask the first question, and then we'll go to the floor. And anyone is any of the panelists are free to answer. So arbitration has been looked at as kind of in Bangladesh, in the Bangladeshi context at least, it's looked at as an elite way of resolving disputes. So there is a perception amongst the people, even lawyers, that only high value claims will be resolved by arbitration. And to an extent, that is empirically correct, because it is very hard to find arbitrators who an arbitral panel which will do your arbitration for less than 10-15 lakhs. So your claim has to be around the 2-3 crore mark for it to be worth it to have an arbitral panel which is costing you 10-15 lakhs at least. That this is the bare minimum kind of. So that is a problem with ad hoc. So do you, the panelists, think that institutional arbitration can solve that and kind of tap into the smaller claim market, claims that are say in lakhs and not crores, and how would you see that problem being solved by institutional arbitration or institutional ADR? Anyone, would any panelist want to
Saqeb, can I make some comments on that?
Yes, yes, Imtiaz bhai.
So I think in Bangladesh, one of the key problems is the is the litigious mind of people. So, for example, if it is against government, you do arbitration, you do litigation, but their thumb rule is that no one is going to pay up unless you have finished all the appeal stages. So what's the point of arbitration anyway then? I mean, you do an arbitration, then you do section 43 district judge, then you go for civil division, then you go for appellate division, and then review. So it's the same thing. And then you have all these dilatory tactics. So, and even in smaller claims, I think the mindset of us is very litigious. So yes, perhaps there is a small claim market, and even, for example, even in a small claim, like look, our default law, section 12, of Arbitration Act says that there has to be default provision is 3 arbitrators. So even if it is a less cost, how much less? So I think there are these gaps in both in reality as well as in law, which are obstacles to sort of promotion of arbitration in Bangladesh. That are my remarks.
Suhan, yes.
I would just compliment and also address. So you've said that whether arbitration is only for the elite or the high value claims. Well, that is where I would like to say that, yes, as you've rightly mentioned, in ad hoc arbitration, when you are discussing fees of the individual arbitrators, is actually very rare that is less than 10 lakhs or so. So, you would have that concern. But if you look at the BIAC fees, the administrative fee of the BIAC, it actually starts from, if I'm not wrong, from 50 lakhs. If the sum of the dispute is 50 lakhs, in that case, the administrative fee of BIAC would be as low as 30,000 and 0.2% of the fee or claim. And then also the arbitrator's fee actually starts from 1 lakh, goes up to 5 lakh. I'm talking about claims of up to 50 lakhs. So, I mean, if you compare it with other ad hoc arbitration or even cost of litigations, I think that the designated fee is not only highly competitive, it's also very attractive as a cost of litigation or cost of arbitration perspective. So institutional arbitration can actually change that idea as well, that is for the elite or the high value matters, or when crores of Dhaka of dispute is involved, we can only go for that. I think that can also change if we accept these kind of fee structures.
Right. I'd like to add something.
Sure.
So in batch matters, and we call them batch matters now. So who has smaller claims, generally? These come generally in debt recovery cases, whether be it banks and financial institutions, or whether be it MSME service providers, or even mid-sized businesses, which may not be multinational or things like that. For those kind of people, at least something that we've tried in India and we've succeeded is that we club all these matters together, take it to an institutional service provider, and we tell them, look, we are going to bring you 30 matters, 100 matters, 200 matters. And so we would like a special fee structure for bringing in large chunks of cases in, one go to you. And so, the fee structures can be negotiated on a lump sum basis per matter. And, and one more very important consideration, and this has worked in India. First, I want to clarify, because this is something very close to my heart. You don't need a law to do pre-court, pre-litigation mediation, right? You just need the will of the parties. I would like to clarify that here. And so, especially in debt recovery matters, we have 500 cases coming in one day to institutional service providers, 5 mediators sitting and resolving maybe 300 debt recoveries, and banks, big private banks and few public sector banks are already availing this, in India. So the thing with small claims is that you can club them and take them to an institutional service provider and avail for an even discounted fee, and reduce the cost to company that you're facing because of that issue. And this can really be helpful, because otherwise your small claims end up in district courts, and the time factor involved in resolving your case at the lower forums is very high, owing to the backlog of
So
cases.
Kritika, I just have a question for you. So who clubs them? I mean, who are the one who sort of pulls all together? Do they have a common respondent? I mean, what is the common thread between all these claims?
So it's a bank. The bank has issued
exactly. So I mean, then one of the key concerns would be the bank is clubbing their claim and taking to an institution. And this is a key problem in arbitration itself, that then there will be an inherent bias for the bank, right? So whether that would be a fair game for the for the opposite parties, because institution would then know that this is my repeat client.
Right. So the way institutional ADR addresses that issue is that the institutional ADR service provider is not going to resolve your claim or is not going to adjudicate your arbitration. They're going to offer maybe a list of arbitrators, and both parties can have the option of just choosing any one of them and saying, this is the one that I want. And the moment you have the option to choose, party autonomy is retained, and hence, the principles of ADR continue even in institutional ADR. That's the general opinion that we have here.
Yeah, but that's very theoretical, right? I mean, if the arbitrators know that this bank is bringing hundreds of claims to me, the institution and the arbitrators therein, would have that inherent bias. I mean, this is even in international arbitration, the law firms who takes, big claims, arbitrators are, friends, and they wine and dine with them, right? So, I mean, so in the name of clubbing, if we are now prejudicing the small claims against a bank, then I think that's a very slippery slope.
Yes, and that's exactly what will happen in our ad hoc arbitration, because that is where you'll approach the arbitrator directly. Another option is that you can go for mediation. Then you don't have a settlement agreement unless both parties agree mutually. Then nobody can blame anybody.
I'd like to bring oh, sorry. Yes, Professor Chowdhury.
Can I ask a question?
We have actually reached out to some of the banks and offered them. I think the answer is not arbitration here. We keep hearing arbitration. Arbitration is not, because again, it is the, litigious, what do you call it? The mindset to go for litigation. Arbitration is almost like litigation.
But Rumi bhai, I mean, if you do mediation,
it's much better. And I know it works. The mindset is that every defaulter doesn't want to pay. That's wrong. Most of the defaulters want to repay and get out of the situation, particularly the small ones. And let me tell you, the worst defaulters are in the big ones, not in the small ones. And the small ones, you can club together and go for mediation. And mediation, you can, the bank can go. Bank is the common thread over there. There's nothing wrong in a bank going for mediation.
Rumi bhai, as a CEO of a bank, I would like to ask you something like, would a bank through mediation accept haircut on their claim? And how would the board view it?
Absolutely.
What would be Bangladesh Bank's position on that?
No, these are approved by the board. Mediation and it has to be approved by the board before the CEO brings them. They agree to the way we wanted to do it If the board agrees to a minimum settlement, and if it doesn't reach those, it doesn't. Not arbitration. We are talking about mediation here. I think this, if COVID situation also showed, I don't want to take any more time, but also showed that, you know, in the mediation is a better choice. You couldn't go for arbitration with these people who walked away from their contracts because you didn't have the arbitration clause in the first place. Even if you went for ad hoc arbitration to the H&M and others, they would just show you the door. The only thing they would agree to is mediation in those cases.
I would like to little supplement with sir. In this way, as you said, what is the Bangladesh Bank position? Actually, while settling down on some claim from the bank, actually Bangladesh Bank has given a worst case scenario approval subject to bank's own board approval, is that you can settle a loan with a principal amount outstanding at the point of settlement. So that there is a huge haircut, you know. So what actually, honestly speaking, I always say that our recovery divisions or a special asset manager division actually does mediation in a little bit different from without a mediator. So
exactly. That is where it is.
Yes.
They should take a third party to make the mediation.
Yeah,
and it's negotiation.
The mediation.
Yeah, and sir, actually, generally a mindset is there that unless a law suit have been lodged or a case have been initiated, I will not pay. That's a natural way of thinking from the defaulter's camp. And if we can little amend it to these things that it can be benefited through some alternate process with a little cost, that will be a start of our success.
Wadud bhai, is it possible to do it in the existing legal the existing legal framework, which is basically there is a post litigation section 22 mediation, but what from my experience, banks are not being really proactive at using that stage to, you know, offer something to the customer, to the defaulter, some you know, a discount on what they have to pay. And the customer is not coming forward either. Is there a scope to, do you think there is a scope to use that provision more?
Actually, this was in my question, which I dropped into the message box. Actually, section 22, again, as I'm saying, you are doing something ADR after initiating a court process. So you are already in court, then in between you are coming through a mediation, wherein the borrowers, which we find that they actually uses this as a technique to just delay the decision or delay the process. So
let me also add, Wadud, you see, because I've been in the board, in fact, I'm in a board now, and I've been a CEO also. So I've seen when the customer goes to the court, the bank board directors take the view that he has gone to the court. Why settle with him? That becomes the issue. So mediation will not work in that situation.
Yeah.
Mediation has to be pre-trial, you know, pre-litigation mediation. Then it has and I do believe very strongly from my years in banking that every customer, every defaulter, so-called, is not really up there to, you know, rob the bank. Many of them want to pay, but they want a good settlement. And let me tell you, Imtiaz, the biggest haircut, Bangladesh government, I think Bangladeshi banks are taking biggest haircut in the settlements from my experience. Huge amounts of interest is being, you know, given away. So, you know, the banks are already taking haircuts in big interest giveaways. The only thing they are not giving away is principal.
I think Professor Chowdhury would want to come in on that point. If you could unmute yourself.
To say something.
Yeah, please.
Yeah, a very conclusive statement when somebody is argued that institutional arbitration, quote, institutional arbitration is the future, unquote.
I think it was Suhan Khan.
No, I'm not. I don't want to mention anybody's name. I don't oppose institutional arbitration. My point was that at this COVID-19 crisis, whether this conclusive statement is always appropriate, question one. And question two, since categorically the regional institutional centers like BIAC, DIAC, HIAC, SITAC, etc., they don't have incorporated online provisions, whether institutional arbitration, like earlier times, whether it could be uh, in the same way better for us at this moment. And thirdly, according to Rumi sir, in line of Rumi sir as well as Kritika, I said to some extent we are very concentrating our talk and focus on arbitration. At this COVID crisis, perhaps, I'm saying again, perhaps depending on the parties, context, culture, these are some things which we should not ignore. And taking these things into account, we should choose whether it should be institutional arbitration, ad hoc arbitration, institutional mediation, or ad hoc mediation. Thank you.
Thank you.
Jamila, I would very quickly actually address, and I totally agree with you. Well, just a very brief experience sharing. That is, when I was involved in the drafting of a couple of EPC contracts in a few turnkey projects. And when I used to draft the force majeure clause and say that if a force majeure clause continues for more than 6 months, in that case, the contract shall stand as terminated. When I used to write that, I used to wonder myself that this is never going to happen, because the force majeure clause, which in an ordinary situation is an earthquake or a tornado or something like that, it wouldn't last. COVID-19 is, in our generation, COVID-19 is a typical example of an unforeseen event, which none of us saw coming, is a force majeure event that is lasting for, we don't know yet how long, at least a year, more than that, 2 years, some says longer. So taking that into account, actually, obviously, COVID-19 has taught us the need for online provisions. But this is something which even our judicial system, the institutions promoting arbitrations, none of us actually saw this coming. And with this, just the way our courts have now adopted e-judiciary, something which would not have happened in the next at least 10 years if this COVID-19 was not there, has actually taken place. And our judges, honorable judges, are now sitting virtually from their home. So this is about adaptability, and I don't see that as a disadvantage of the present rules of the institutions. I see that this is a way which the institutions will adopt, just like the way the whole world is adopting to that. And regarding the mediation, I also completely agree with you that, we are talking, when we are looking into institutional mediation and institutional arbitration, institutional mediation may also be the future. And that is why probably I would also like to mention the MEDARP clause. And I believe BIAC also has a MEDARP clause, and this is increasingly becoming popular outside of Bangladesh as well, that parties at first try to do mediation. If it fails, then they go to arbitration. Either way, we have an alternative dispute resolution. The only good part about institutional, having an institution involved, is that in institutional MEDARP, the party, one of the party cannot take advantage of the mediation provision, because there's a time limit for mediation, that if parties cannot conclude a mediation and come to a settlement, they'll have to go to the arbitration. That way, having an institution involved and having a MEDARP clause could actually address what Jamila, you were addressing, and other discussants have already addressed. Kritika and Imtiaz, Farooq bhai, they have also addressed. I think MEDARP clause is the easy way out in that aspect.
Yeah. I think thank you, Suhan. I think one comment that I will pick up on in the chat box is the issue of credibility. So whether you would think, the panelists, that an arbitration award or a mediation settlement that has come out of an institution would have a better credibility in an enforcement scenario. So we're looking at, say, there has been an award from BIAC, which has come out of institutional arbitration from BIAC, and whether when obviously the party which has lost has the option to go to court to set aside that award. Would the courts view this award as slightly more credible or substantially more credible than an ad hoc arbitration award. What do you think about that? Suhan, you can start, and then maybe we can go through the panel as well.
Well, certainly, let me, speaking from my experience perspective, when I go for enforcement of foreign arbitral awards of ICC or of GAFTA or FOSFA or SIAC, what I have experienced in the district court is that whenever we presented that this is an arbitration award by the ICC, there is this perception of an institutional presence and the sense of acceptability, which is not expressly stated, but there's this perception which is there, as opposed to ad hoc arbitration, which I've not experienced in international arena anymore. We don't see it any longer from a Bangladesh perspective. So having an institution in Bangladesh involved would, in my humble opinion, definitely give an upper edge to the parties seeking enforcement. And also,
it would be very hard to argue that this award has been, has procedural issues, or like this has somehow been obtained, dishonestly, or etc. So these claims would be very difficult to make in an execution court or a court which is
certainly. And you are also closing, certainly, Saqeb, and you are also closing that whole doors of challenging the arbitration award, which we see in case of local ad hoc arbitrations. The room, I think, will be minimized.
As Kritika said, we have a tendency to appeal everything until the appellate division review stage. So if we can use the an institutional arbitration award as kind of a final judgment on what our claim, that obviously that is advantageous. Does anyone want to? Imtiaz, would you like to comment on that, or Professor Chowdhury?
Just final word from my side. Yeah, again, institutional arbitration, regarding institutional arbitration, in terms of ad hoc versus institutional arbitration award, obviously it is more credible than institutional arbitration. At the same, on the other hand, if I just go through the Article 43 of the Arbitration Act, there is a long procedure for challenging this one, and that is set aside of the foreign arbitral award or award, whatever. But this is again a long procedure. So the we are choosing ADR for what? For mitigating the time, mitigating the cost. These are the benefits that make the difference between ADR and a binding arbitration or institutional arbitration versus litigation. If we don't get that one, and we are again go to High Court division for the national arbitration, for international arbitration, district court for national arbitration, and High Court for international arbitration. So again, matter of time. So my question is that how far you justify these kinds of gap, that we are getting a word, but that can be challenged. That is again a long procedure. And so I still have some reservation here. Okay, thank you.
Thank you, Mr. Osama Taseer. Sorry.
Sorry, I just had one small comment. Like the whole, coming back to the banking sector problem. Like nowadays we see a very interesting phenomena that Anti-Corruption Commission are now looking into how loans are given and loans are settled even in private banks, right? So if it's a very curious question that arises, that if through mediation or through, in proceedings, in between settlement, you take a severe haircut, then what if Anti-Corruption Commission start taking a keen interest on what has happened? So I think the overall, the mindset in the society and the mindset in regulators or the government is the fact that unless the court endorses something, nothing is credible. So I think, on the question of credibility, that's a very, very important issue.
I can add over there. No, the choice is very stark, Imtiaz. The choice for the country is very stark. Either we remain 189th out of 190 countries in enforcement of contract, or should we become credible to the rest of the world? That is the choice. And I think we should be aware, all of us should be aware of that. The choice is that.
I would absolutely. So I think that's where the stakeholders need to be brought on board.
And that's why you are there here discussing it.
Osama, Mr. Osama,
there's a small question for Rumi Bhai on the chat box. Mr. Imtiaz is sharing. Can you see that?
Ishtiaq Bhai has shared
can you highlight on this what happened with this case?
An experience where he tried to mediate a loan through BIAC, but the bank wasn't very very cooperative, I think. So
maybe I don't want to go into the details, obviously, for
specifics of the case, but from a general perspective.
General perspective.
Yeah.
It's on the chat
but
box.
In general, I think, if I may say so without trying to hurt the sentiments of anyone in particular or any particular type of people in particular, it was the lawyer at the bank who was against. And again, the issue was, he was of the opinion that we'll settle in the court because it suited him to go to the court for obvious reasons. I want to go into that. He just wouldn't. Although, you know, I reached out to the managing director also of that bank and spoke to him. He was very keen. He said, I want it as a test case.
Right.
He wanted to finish this as a test case and, you know, it would show the road for others. Because at that level, they are interested in quick turnover. Yeah. You see, if I can quickly finish a loan and turn over my book, it makes more money for the bank.
Yeah.
And Wadud, I'm sure, is going to agree to that.
Yeah.
Just one
sir,
more thing.
I would like to...
One more thing.
Yeah, Mr. Taseer, please.
Just to tag on to the question you had for the RMG contracts, for international contracts, I think it is high time that we look into the mediation or arbitration clause, whether it's incorporated in the contracts. So how to do it, I think you're the best people to suggest it. We are just plain business.
Couldn't agree more. Couldn't agree more. And I can tell you from my own experience with these international buyers, where I was a member of the board of the Alliance for Bangladesh Workers' Safety for 3 years, when it was formed after the Rana Plaza disaster. I think, you know, we must learn how to negotiate. We must learn how to do our contracts. We must learn how to mediate, and mediation works better with them because they want confidentiality. They don't want a situation where the newspaper is going to say they haven't come to they like the confidentiality, particularly the global brands, because brand is their value. Brand is everything for them. Anything that affects the brand, they'll protect. So they are more likely to come for a mediation than for an arbitration. If you ask for arbitration, your chances, and law courts, they'll avoid. So it's best to go for mediation if you want to settle with them. That's my view.
Sir, if
you can have the last say on the session and we can close.
Yes, I just want to say.
I actually looked at least 15 contracts done by the garment industry people with their international buyers. Not a single one had any, no, that would be wrong. Maybe 3 or 4 out of that had, mere clauses for dispute resolution. There was nothing in the rest. Absolutely.
The default is that buyers have to be sued in their home courts. So which is extremely impractical.
The lawyers should be, but they didn't go to a lawyers perhaps. I don't know. Yeah. Their jurisdiction is all in international courts where a contract of $500,000 or $100,000, they won't be able to step into the court with that kind of money.
Yeah.
So how much do you make in a $100,000 contract? Maybe $10,000, $20,000, $10,000. I don't know. There's Osama here who will answer the question. But 10,000, 10% margin, profit margin. So that will go for litigation. More.
Just want to add a line here. Two key issues that were raised here. One was that banks not willing to settle in debt recovery matters, and the bringing public sector undertakings or government undertakings to the table. We've been studying these cases as well. And what we've been doing in India is that banks generally, both banks and PSUs, once they've decided as a policy that they want to settle matters, banks come with a one-time settlement scheme, and they offer the scheme uniformly to all their debtors. that this is the percentage of loan you need to pay. And if you, and credit rating is being used as a big mechanism to make, borrowers pay, because it affects your credit rating if you don't accept that scheme. And, and when it's offered uniformly and the board of a bank has already taken decision that this is how it's going to be, people tend to implement it. As a motivation, that for the legal team, many banks have started this, that, an award is given to the lawyer who is able to settle the more number of recoveries in a year. He is awarded, best employee year of the year award, kind of a thing. And when it comes to PSUs, they send a representative to mediation, but they have an internal committee set up. And whatever decisions the PSU takes in a mediation, it is put up before the committee. They as a whole approve it. And when that happens, we have a sister organization here called Central Vigilance Commission. It doesn't come under the purview of CVC because, a group has taken the decision, and it's very difficult to bribe 10 people at one go. That will not be cost effective. So.
I think there's a lack of an incentive structure even for lawyers appointed by banks for settling cases early. So that could probably be one of the reasons why banks counsel are not very cooperative when it comes to mediating or settling. So maybe perhaps that's something our only banking representative or current banking representative Wadud bhai can look into. You want to?
I love to answer this.
Have some last words. I will close this session and I'll hand over to.
Okay.
Please.
So actually, I would love to answer this question.
Yes, Wadud bhai, yeah.
Because you see, if you think about the banking industry, we have millions of retail cases which are actually need settlement. Now think about this case amount. Bangladesh Bank has given a special approval that after below certain amount, you can write off that loan without even going to the court cases, because there is a cost issues there. So in this particular smaller amounts, wherein actually bankers are willing to settle it down after a settlement arrangement. For example, if you talk about few banks, or if you ask that, where are you interested, or give us some cases, I'm sure banks, subject to consent from their boards or others, they will coming up with thousands of cases wherein sir, these are the cases from my side I would like to settle under a settlement arrangement through mediation, because for going to the court, even it will be more costly. So I think mediation, especially for the smaller cases, even for the larger cases, actually, it has a very good prospect in our banking cases. For example, I have gone to the court, and probably the cases are pending for certain periods of time, but the borrower knows that sometimes I will need to face the court, and as the money is going from my pocket to pay the lawyers or court fees or others, so let's settle it down. So as a test case, actually, if want, even if BIAC wants, we can give some cases subject to my board, the smaller cases and larger cases as a pilot cases, which can be brought in under arbitration or can be brought in under mediation for smaller cases. That would be a right choice. I think so. So I believe that actually, depending not on a smaller cases, case issues, I think you should believe that bankers are willing to settle it much more on mediation, through mediation or arbitration. Actually, as I said, our recovery teams are settling down through some settlement with the borrower. Actually, it is also one type of mediation, as I said previously, without a third party. So when a third party comes, it will be more reliable and more trustworthy. So it will work much more effectively. So that's my comment.
Thank you, Wadud bhai. Thank you. I hope your thoughts are shared across the banking sector. So at this point, we are closing the Q&A session, and I would like to hand over the floor to Mr. Muhammad Rumi Ali, who needs no introduction, who is the CEO, current chief executive of the Bangladesh International Arbitration Center, BIAC, and yeah, as I said, he needs no introduction. So I'm signing off here, and yes, Mr. Rumi Ali sir, the floor is yours.
Thank you, Saqeb. It's been great. You know, it's music to my ears what I'm hearing, particularly what Wadud said right now, that he's going to come to me with a few cases. That sounds great to me. But we have, I think that's what we would like to. We'd like to see more institutional mediation. And although, you know, also arbitration, but both on an institutional basis. The thing is, of course, you know, the issue about which has been raised about COVID changing the whole scenario, it has changed it, but I don't think it is a permanent change, as someone correctly said, and I think it was Barrister Suhan who mentioned that this is a temporary thing, and the institutions are going to change their rules, and the institutions are allowed to change the rules, but you need rules because an ad hoc arrangement can only be done for that particular mediation. And that is why questions are asked. If you ask me, what is the definition of governance? Governance means two things, transparency and accountability. These two can be questioned when two parties sit down and agree everything, because there is no other reference point around you. So I think you will for the sake of governance, institutional mediation is an absolute necessary. And you must also consider that Bangladesh is not an island. It is in a community of nations. And we have seen globally, institutional ADR has taken off. There is no example of countries where ADR is happening on ad hoc basis nowadays. Everywhere it's institutional. And there's a reason for it. And the reason is precisely what I was saying. It is governance, because you have a set of rules, you have a board, the institutions have a board, or you know, it's either a non-profit or for-profit, whatever it is. It operates within certain rules which are open for public to see, and records are kept. I don't know how long the records are kept. You can come back to BIAC after 5 years and get the records, whatever we have. If there's a court order, we can produce the records. But those are the things we, you know, an institution, the cover an institution gives. So I think, you know, I don't have to say more because you are the experts, and I've heard in general, you all agreed that institutional ADR is perhaps, should be the chosen way forward. However, you know, we are the only licensed ADR institution in the country. We are trying our best. We have done a lot of things. You know, we started in 2011. I joined in 2015, and I can tell you from 2015, we have received recognition from many institutions, global institutions, including the PCA, the Permanent Court of Arbitration, SIAC, then the Singapore, Hong Kong, Indonesia, India, China. In fact, our chairman, Mr. Mahbub, is a accredited arbitrator for CITEC. That is the Chinese government agency for settling disputes, commercial disputes on ADR. And we are now holding, you know, advocacy sessions. We are holding outreach sessions because there's a lot of misunderstanding about ADR, lot of perceptions about ADR which are not correct. So we are trying to reach out to institutions, which means the universities, to get in touch with the students who are the future arbitrators and lawyers of this country. We are also reaching out to the legal profession through the chambers and directly on one-to-one basis. We are reaching out to the government, to Bangladesh Bank. Let me tell you that I was in a committee. I was the convener of a committee set up by Bangladesh Bank to recommend how we can bring in arbitration and mediation in recovery. And I submitted that to Bangladesh Bank about a year back, our recommendation. The committee included the bankers and the central bank and the Association of Bankers, Bangladesh. And we gave the recommendations, but unfortunately, it hasn't seen the light of day. And things like mediation for the small borrowers, these are things which have been recommended, that up to a certain amount, it will be mediation. Beyond that amount, we go for arbitration, the big sums, but all basically in an institutional setup. So, we are trying, but I am right now reaching out to you because you, particularly the lawyers, are the community who need to actually push this. I'm sure our professor over here will talk to her students, and she does, I'm sure, from what she said about institutional mediation and arbitration. The bankers, I think I talked to bankers having the benefit of being a banker. I have been able to reach out to them. Unfortunately, I have not been a lawyer before. But I'm reaching out to them. And that is why I said it's music to my ears, because the lawyers have started saying that institutional arbitration is necessary. Thank you very much for all of you for coming here and talking. And I think we are going to actually put this together, whatever each one has said. I think this is very important, particularly the recommendation of looking at our rules and seeing what can be changed to make it more friendly for e-arbitration or e-mediation. And we are going to do that. So with that, I would like to thank Osama, Taseer, the former president of DCCI, who's given a very good presentation. Barrister Imtiaz Farooq. Thank you, Mr. Farooq. Barrister Suhan Khan, Dr. Jamila Chowdhury, Wadud from Citibank. I said Wadud because I know him from a long time, so I chose to address him by his first name. And Kritika, thank you, Kritika, for coming and giving a very interesting, different perspective. I didn't expect that because you put in the psychology of a person and what he goes for and what doesn't go for. I haven't thought about it from that angle. So thank you very much for your presentation. And thank you all once again. Do support BIAC. Let's have institutional mediation and arbitration in Bangladesh. Thank you very much, all of you. And particularly to our moderator, Saqeb, who I rang up and requested to. He's done a brilliant job of moderating it. And
thank you.
I am sure he will help us in future also in moderating and speaking at our future webinars and seminars. And also help us whenever we need in terms of changing the rules and laws of, particularly the rules of mediation and arbitration of BIAC.
It will be a pleasure.
Thank you very much, all of you.
Thank you, everybody. Thank you.
Thank you.
Thank you.